Good afternoon, good afternoon, good afternoon. Hey, it's Mark Wallace, your host and facilitator of the People Show with you here every Saturday. We're starting a little bit late today, so please forgive me, and I hope that you all still continue to join us. Judge Leonard Murray is going to be joining me in just a few minutes. And of course, we're going to be taking on all of your legal questions that you have related to any court proceeding. Remember that the judge cannot give you any type of legal advice, but he can certainly answer your legal questions. And therefore, we will. So some may consider that as advice, but it's not advice. He can't give you personal legal advice on what to do with your particular case, but he can certainly answer legal questions. So that's the difference in how that pertains and relates to the law and the Constitution. All right. So when you come on and you have a question for Judge Murray, just write your question in the post it in the chat. Post your question in the comment section, and I'll read your question off to Judge Murray, and he will address your for Judge Murray. Okay. All right. So Judge Murray will be joining with us in just a minute. So let me just say, there's a lot of things going on. I just came from a meeting called Coalition of African American Leaders, who president of that is Craig Wembley, who is also a part of the 10 by 10 to win voting block collaboration, where we are collaborating all across our diaspora of Black voters, citizens in the city of Chicago, the county of Cook, and the state of Illinois. And for that purpose is so that we could become a lot more connected, a lot more collaborative, and that we can discuss, deliberate, and decide who it is that we're going to have as candidates that we are going to select and elect for public office in all of the offices, whether it be school board offices, whether it be aldermanic offices, whether it be mayoral offices, whether it be board commissioner or board president or governor or lieutenant governor or state rep, state senator, state's attorney, attorney general, all of these important offices, and those that I did not mention, like treasurer, clerk, recorder of deed, board of review, assessors, all of those critical offices that have direct impact on the lives and the quality of life of our communities. And so I just came from another meeting, and I go to meetings to be, one, supportive, two, to be informed, and the other is to observe what our progress is. What are the outcomes for the actions for which we take? And part of our problem, a large part of our problem, is not that we don't have the information, because we absolutely have the information. We have bright, brilliant people who provide us with the information, who share the information on the respective issues, from education to economics and all of the other social concerns as it relates to our communities. We've got all of that. I gotta do something here because I think, I'm sorry. I had to make sure that there is. Okay, here we go. All right, that's better. So that we're not shooting in the dark. And I don't mean this as a critique in a negative light, but it's an observation. We've been shooting in the dark We've been shooting in the dark and we've been missing more than we've been hitting, meaning that we are participating in the growth and we're participating in the process in the dark. What I mean in the dark is that it's hit or miss. It's not deliberate. We have to become deliberate, which means that we have to organize ourselves. We can no longer become or be as fractionized as we are. And we cannot afford individualism to be the driving force for us. And individualism is preceded by inflated egos, whether it be conscious or whether it be subconscious. That's what drives individualism. But a collective, united body is a group of people who are interested in the progress and in the prosperity of our people as a whole, not for individualized grandeur. So we are interested in participating, and those who are interested in serving in those positions of public trust, that needs to be determined by the masses of people. But in order for that relationship to have the positive outcome, we have to build the infrastructure in order for us to meet the needs of our communities, to make sure that our communities are thriving. That means that we have to have a complete transformation, fundamentally, how we engage the process. And the fundamental transformation is that we have to go from individualism. This represents individualism. This represents organized, collective collaboration. We cannot allow for ourselves to be separated, that we will have no effectiveness, of no effective outcome for our people. Nobody should go into a public office for the service of a few, of a preferential few. You go into the public's office to make sure that your work is about elevating the public at large. And thusly elevating the public at large, we will be able to grow people who are looking to be in business at whatever the area of contribution that we are or that they may desire. But we've got to organize ourselves differently, and we have to participate in that process vastly different, fundamentally different than we are currently participating and then we have participating at past. Every election and in between elections, we are absolutely shooting in the dark because of one fundamental breakdown or one fundamental thing that we have never done, and that is to be organized. So we have to discuss, we have to be deliberate, and we have to decide on what outcomes that we need to have and how we have to get there. And we cannot get there, and we're not going to get there continuing in the same patterns and the same fashions that we have continued. So we're going to be talking about that on Monday night, coming up on the Monday night edition of the People Show. I've got some guests that are going to be on with me. Kim Delaney from the DuSable Museum may be on with me, and some other people I've had some conversation with today. We're going to be talking about the Board of Elections races that are going to be happening in November, and people are trying to get their signatures together to get on the ballot. They have to have 1,000 signatures in order to make the ballot. So, and that's more than an alderman needs to have. An alderman only needs 400 and some odd signatures, and a person now who wants to get on the school board has to have 1,000. So we're going to be talking about that on Monday night's edition of the People Show. So make sure you look for that and tune into that program. But I am going to consistently move for us that we must, if we expect to make any type of significant progress by measure for the Black community, for the diaspora, is that we have to collaborate. We have to connect ourselves together. We have to build an independent Black voting bloc in order for us to impact all of those issues, from education to economics and everything in between. So look for that Monday night at 7:00 right here on the People Show. All right, joining me now for our legal hour, Judge Lyndon Murray has arrived, and he is here with us, and we're going to be answering your calls, or certainly not your calls, but your questions that you'll be able to write into the comment section, and then Judge Murray will hear your question, and he will respond to your question. Now, remember, he is the circuit court judge down at the Daly Center, Cook County, of the Housing Division, and the supervising judge of the Housing Division and over the administrative review. So those of you who get those pesky little red light camera tickets and speed camera tickets, and you want to contest them after a decision has been made at the administrative review or administrative hearing, you can have an administrative review, and the person who would initially take you in will be that of Judge Lyndon Murray. Judge Murray, welcome to the program.
Good afternoon, Mark. How are you?
I'm doing great. How you doing?
Good. Had a little problem getting on this afternoon, but I'm here.
All right, fantastic. And I was a little bit late getting you the link, so my apologies to that. All right, so wanted to talk about, we discussed earlier this week on some things that we would focus on talking about, in addition to taking questions from the viewers and the listeners as to their legal issues. So there were a couple of things that you and I talked about, and that it is about really about the process, right? Respecting the process and people responding to their summons. Can you elaborate on that? We'll also talk about forfeitures, but we want to talk about the summons and the importance of people, what that means to people when they get a summons to go to court.
Sure. So due process requires that someone against whom relief is sought. By that I mean you've got a person bringing an action, and they're naming a company or an individual against whom they're seeking relief. That company or person is entitled to notice. Depending upon the nature of the proceedings, they're actually entitled to actual notice. By actual notice, I mean that they should be served with papers that tell them what the action is about, where it is, where it has been filed, uh, due dates to appear, and what you're required to do in order to assert a defense to the action. We essentially call that a summons. Now, depending upon the nature of the proceeding, there are two methods by which, or two types of jurisdictions that courts exercise over controversies. First, there's this actual notice, which I've mentioned, and that's when you are actually served, and that could be those papers handed to you, or handed to a member of your household who's old enough to receive them at a place where you live. You can't have actual notice unless they're given to you or place that you reside. So they couldn't be left for you at your athletic club, for example. That wouldn't work. Uh, and then there was a subject matter jurisdiction where uh, you can be served constructively. Give you an example of that, and that's where, for example, if there's a foreclosure of property based on a mortgage default, um, then after attempts are made to give you actual notice, again, meaning either the papers handed to you or handed to someone where you reside of a sufficient age, then they can put a notice out there in the ether uh, by newspaper or some other means pursuant to rule where you are constructively given notice. Now, in addition to, for example, notice in a newspaper, there also must be certain notices or facts about the litigation sent to you at an address where it is suggested that you reside. Um, that's constructive notice. Now, actual notice entitles the court to enter a remedy against you personally. Uh, for example, in a foreclosure case, there could be a money judgment if there's a deficiency involved once the property is going to sell. There could be a deficiency judgment against you personally. Uh, but if it's constructive notice, the judgment entered in that case can only be against the property, can be against you personally because you don't have actual notice of the proceedings. Um, so that's the difference. I'm really giving you a simplified explanation of it because it can be complicated. Um, but that's an example of how folks are given notice of proceedings and the two methods by which most judicial systems will accept. And of course, once you are put on notice that there's something pending that involves you, it's important that you respond to protect your position and defend yourself. It's critical that you just don't ignore it and miss dates and so forth because sometimes it reaches a point where if you wanted to defend, it may be too late.
Well, also, now in someone not showing up, uh, talk about the importance of someone not showing up, and as a result, in particular, if they're a defendant, not showing up, it, in many respects, the court is going to assume that whatever the plaintiff is providing is true and correct, and is going to make a decision based on that without having the benefit of hearing from the other side. Can you talk a little bit about that?
That's correct. So uh, typically, law complaints are required to be they have to be signed. If it's a lawyer involved, they must be signed by the lawyer. If it's a person who representing themselves or pro se litigant, then they must be signed by that person. And there is a procedure under Illinois civil practice where that you certify that the claims made, the allegations made in the complaint are true and correct. Um, so if that has occurred, but it's not necessary that certification be present on every single case that's filed. Um, if that certification is not present, then the plaintiff in the action must then either give testimony in court that what's in the complaint is accurate, or can support it by an affidavit in lieu of actual testimony. So as you have suggested that if you don't respond to the complaint, to the action, then a court may assume that what is said is true. And we all know that that's not always the case, where the allegations suggested in the complaint are true. It could be something that somebody's fabricated. So in order to protect your position, it's important that you respond, answer the complaint, and usually that answer is not complicated. It's really just, I agree with what's in paragraph one. I disagree what's in paragraph two, and you go on down the line until you fully answered every paragraph of the complaint. And it's not rocket science. It's something that the average person can probably accomplish with just a little effort. Um, but as you suggested, if you fail to do that, then a judge may consider what's in the complaint as being true, any absence of hearing the other side, as you suggested. Now, of course, I think I've always believed it's important for a judge to read what people put before them, not just accept it as true, because you can ferret out and use your own common sense in terms of these allegations as to whether or not they make sense and whether or not they entitle the person who has brought the action to recover, and for the court to exercise its authority to enter a judgment or some other adverse order against that person. So by appearing and responding, then you preserve the ability to object to what's being done, and also present a defense and go to trial. And at trial, both sides have the opportunity to give their version of what occurred, and then the judge's role, the jury, if a jury is requested and permissible in any action, they'll decide what the outcome is.
One moment, Judge.
Okay.
Sorry, Judge. That was somebody calling in the middle of our conversation. I knew that was going to happen. They were supposed to call early. All right. So, yeah, because a lot of people not showing up to court, then, a judge issues a judgment in favor of um, the person who showed up to court, which in most cases, the plaintiffs, and that information may or may not be true, but the court doesn't have any other information from the other side to be able to consider. So at that point, other than the court may saying we'll pass it or something like that. But what are when you do have people who just don't show up to court, right? You may pass it for a few minutes and wait for a person to show up to court. And if they don't show up to court by the time your calendar ends and that plaintiff comes back, you give them a judgment in favor of whatever it is that they're asking, because that's all the information that you have to consider.
Yeah, that happens pretty frequently. There are a number of cases where parties don't respond to summonses to appear, and where the document upon which the case is brought appears to make some sense, is accurate. There's enough information that is alleged and pled that is sufficient for a court to conclude that the remedy sought is allowable and also has merit, then more likely than not, a ex parte judgment, meaning the respondent doesn't appear, is going to be entered.
Okay, and if that person, say, some people forget that they have to go to court. It does happen, because usually court dates are 6 weeks out, could be 8 weeks out, for whatever reason, a number of reasons that people could forget, and then they get some information that a judgment has been entered into them, and they want to come into court to have that judgment vacated. What is it that someone would have to do that, and can they do that?
It is possible. You should act, though, within 30 days of the entry of the judgment. Uh, that gives you the opportunity for the court to consider it. If you're beyond 30 days, it becomes more difficult. So it's important that if in fact you have had a judgment entered against you and you want to defend it, uh, then you should act within 30 days. And by that, I mean file a motion to vacate the judgment. You don't have to get into court within that 30 days, but you do have to file the document or the motion within 30 days of the entry of that order. Um, it is, once a final order is entered, uh, the ability of the court to consider it without a lot more effort on your part, it must occur within 30 days. And again, please understand that the motion to vacate the judgment is what must be filed. And by that I mean with the clerk of the court, must be filed with the clerk of court within 30 days. However, it's not necessary that you actually present the motion within 30 days. It's just you got to get that motion on file within 30 days. Otherwise, it becomes a more difficult proposition. Now, the exception to that is where you can demonstrate that you were not served, meaning that although the plaintiff is asserting that you were actually served, you can demonstrate that I was not served. In that case, the court didn't have jurisdiction to enter the judgment because you were not served. You were not given actual notice. And in certain matters, jurisdiction can be based on constructive notice. That's where publication is involved. But if it's a situation where the claim is that you were actually presented the papers that underlie the legal action, and you can prove that you were not served, then in that situation, you can actually attempt to have the judgment vacated even after 30 days.
To show that you're not served. And then service is, what is considered to be service? There are some people who, duck service, right? They know that they're going into court, or know that the other side is trying to get them into a court to bring some remedy to whatever the dispute is, but the person is avoiding service. And here in Cook County, you file an action, you file it with the sheriffs, and then the sheriffs send out a service unit. Now, so what is considered to be actual a valid service? Let's say that somebody comes in and they say that, Your Honor, the sheriffs went out, and I think they go out twice, and they were not able to serve. They got a special process server that was approved by the court to go out to serve this person. And the special process server comes back with their report and says, well, we went to serve them at the address where they reside. Someone came to the door, but they wouldn't open the door, but we certainly spoke to them through the door. Could that be considered as service by the court?
Well, that gets to be tricky, where the person is refusing service. You really can't refuse service. But if there was an engagement at the door and the person, be it sheriff or special process server, um, uh, interacts with the defendant in that situation, um, then you might be able, and actually the papers are left somehow, such that the defendant could be made aware of them. Then that might be good service. It's a factual determination based on what occurred. But the safest route is to make sure you actually present the papers to the person. For example, um, if the server, meaning sheriff or special process server, comes out, is waiting for the person, for example, to come home, encounters them on the street, and says, "I've got papers here to serve you," and they say, "No, I'm not going to accept them," then they can't do that. They can't refuse service in that fashion. Um, so, but of course, if you're not at home, and these attempts occur to give you notice of the proceedings, and it doesn't occur, then that would not be good service in that situation. So it's really an analysis that requires um, information about what actually occurred when the attempt was made to try to give the respondent or defendant in the action actual notice.
So there could be circumstances that will move the court to accept a special process server explanation of service, even though a person refused to physically take the documentation, but there was an exchange of that information by the special process server, and the special process server signs an affidavit stating such. So the court could rule upon that as service depending upon the circumstances.
Correct. Correct.
Well, and I would think that that's more likely to happen with special process server than it does with the actual sheriff's department, because the sheriff's department goes, I think it's 2 times that they actually go to try to attempt to serve, but they don't, obviously would not go through the lengths that the special process server does, which is why I guess they're called special process servers, to serve them. So, and speaking of the special process server, special process servers, are they appointed by the court or are they approved by the court?
No, they're appointed by the court. So in order to have someone other than a member of the sheriff's office, a sheriff's deputy, serve papers, you have to file a motion with the court and suggest who you would like the court to appoint to serve papers in this situation. Without that service will not be valid and it won't be accepted. And also, it's important to know that the summons itself has a certain life. Typically, the summons has a life of roughly a month. So once the summons is issued by the clerk's office, it must be served within a certain period of time. If it is not, then that summons is invalid, and you have to obtain a replacement summons, or what's called an alias summons, because the original summons could not be served.
Okay. What happens with a plaintiff, or not a plaintiff, but a defendant who is a tenant, who's a tenant is in the process of going to eviction court, and the owner of the property is seeking for possession of the property, but they're also seeking money damages. 5-day notice services. Is it acceptable for someone to serve a 5-day notice by leaving it taped to the door, or are they required to hand deliver that to some person who is above the age of 13?
Okay, now, the service of the termination notice, a 5-day notice, and there are other types of notices that apply to possession of real estate.
Mhm.
I don't believe it's a good practice to rely on leaving the notice in some fashion other than handing it to someone. Uh, f- uh, Certainly, if you tape the notice to the door, you might suspect that the person coming in and out is going to see it, but you can't really prove that they actually got it. The example I always give is if you live in a multi-unit building uh, and there are more than one apartment on the floor, that's the subject of the suit for possession, and you got a mischievous kid who is the neighbor, and he comes out of his unit just in his normal fashion for going in and out, and he rips off the notice, then that's not service. It's only service if the target of the notice will acknowledge that they received it. But if you rely on taping it to the door of the unit, believing that certainly the tenant or person in control of the unit is going to um, receive it, that's not really reliable. And also, in court, you couldn't testify under oath that you gave it to them. Your testimony would be, "Well, I put it on the door, but I don't know if they received it or not." That's not going to work.
And if somebody does a notice by posting, meaning they were not able to get service on the person, um, that they did it by posting, meaning that they had to post it, publicize it in a local newspaper as whatever the requirements are, by posting. Does that eliminate them from being able to have a money judgment, as well as to having possession?
Okay, so now we're going back to notice of the actual lawsuit versus
Right,
notice of the demand.
right.
So the courts can only enter money judgment if they have personal jurisdiction, meaning that the defendant in the case has been given actual notice of the lawsuit. So in many landlord-tenant situations that involve what I call a rent default, if you are seeking, well, let me back up. In the forcible entry and detainer statute, you must be seeking possession. Um, you can add a claim for rent, or join a claim for rent as part of that, but the subject matter must be possession. Now, you don't have to have personal service in order to seek possession only. Court can exercise what's called in rem jurisdiction, meaning jurisdiction over the subject matter, which is the property. Similarly, in foreclosure matters, courts can exercise in rem jurisdiction over the property without actual service as well. Now, the way that you obtain in rem jurisdiction, you must at least make a diligent effort to give actual notice, meaning having served the defendant personally. And if you've done that and can demonstrate that you've been diligent and you've made sufficient efforts and have been unsuccessful, then you can resort to what's commonly called posting, and that is done with the sheriff. Uh, there's certain an affidavit that you file to support the attempt to serve or the service by posting. Um, and in that affidavit, you spell out what you've done in order to give the defendant or tenant actual notice, but have been unsuccessful. I have when I sat in lieutenant court for probably close to 7 years, and one of the affidavits that commonly was used was that the lawyer for the plaintiff would sign the affidavit. And I always warned against that because what effort did they undertake personally, that is, to effectuate service on the tenant or defendant? Uh, Usually nothing. They're just signing an affidavit from the comfort of their office chair, but they don't do anything to ascertain where the defendant is. I always thought those were risky affidavits. Of course, if it's presented and goes unchallenged, then the court will accept it. But if someone comes in on a motion to vacate a judgment in that situation, uh, and the affidavit is challenged, I think it's problematic for both the lawyer and the plaintiff because it does not demonstrate diligence. And there is a fairly uh, old case that's often cited in that situation called Bank of Ravenswood, that demonstrates the need for diligence in terms of giving defendants actual notice of proceedings and not just relying on what we commonly refer to as posting notice. But that notice is one that the sheriff actually posts around the county. They post in the Daily Center, on a bulletin board in the Daily Center, and they also post on a board over um, in the city county building, on the county side of the building. They post that notice, and then they're also supposed to mail one to the claimed address for the defendant in the action. That's in a landlord tenant situation. In a foreclosure situation is different. The notice that posting notice that is allowed there is typically uh, put in a newspaper of common circulation. Most folks use the Chicago Daily Law Bulletin to publicize uh, foreclosure matters, and then also there, likewise there, uh, the newspaper will send notice to the defendant at the address suggested as their residence.
Wow, that's very, very eye-opening there about that. I know that I've had a lot of questions about that. Other people have had questions about that very same thing. Okay, what we got a few minutes left. We certainly want to get into the forfeiture part of this of discussion, because I think these are two areas that are, vitally important that most people don't. I think that they don't really think about the real importance of just showing up, and this is all a part of that, is making sure that one, there's that you're properly noticed, and then when you do get notice, that you show up so that you can be heard by the court, to be able to argue, or certainly to defend yourself in these matters. I talked to you a few weeks ago about some real examples of two people that I know of that are in foreclosure. The foreclosure has taken place. The public auction has taken place, and the property in one of the instances went back to the bank or to the lender, and the lender, we found, had sent 3 different conservation crews out to change locks and all of that without the case being fully decided or adjudicated by confirmation. So in each one of those cases, we had to contact the Chicago Police Department. Chicago Police Department came out and told them, unless you have a court order, you can't do it. But the fact is, they did it on 3 different occasions. They went to the confirmation hearing. And explained that to the court, because I remember asking you, is that going to make a difference, or could, the judge decide to throw it out or dismiss it, or say to the other side, look, you got to start over. But in this case, he didn't do it. But what he did do is he continued it twice. Any idea what he could be considering? He said that he wanted to know, one of the questions that he raised to the plaintiffs is that he wanted to know, why did this happen? And they couldn't give him any good reason. Obviously, the attorneys couldn't give him any good reasons because apparently they don't have any knowledge of it. What could the judge be considering to do at that point that he's continued that confirmation twice?
Well, I probably, assuming the case, there's jurisdiction, meaning that the mortgagors had notice of it either actually or through constructively through publication in the newspaper. There has been a trespass here because the mortgagors are still entitled to possession of the property. There's no possession order that's been entered that to disturb that right. So he could be considering what would be an appropriate sanction given the conduct, which seems that the lawyers for the mortgage company aren't disputing. They're not denying that this occurred. They may well not even have been aware of it. So it's interesting that they're not coming to court and revealing why their client did what they did. But he or she could be considering what is an appropriate sanction given what apparently has occurred and is not denied. It could be money, but I doubt that it will disturb the underlying foreclosure since it doesn't appear as if there was a defense to the actual, default in paying the mortgage, making the mortgage payments under the agreement. It may well be that they're considering what would be what if any sanction is appropriate given what's occurred here, that the mortgager's right to peaceful enjoyment of the property until such time as their rights are taken away has occurred. And how should the court make an example, or if the court should make an example, I should say, of this situation so it deters this conduct going forward.
All right, let's switch over to forfeitures. What does that mean, forfeitures?
Okay, so under state law, local governments have the right to ask the court to take away ownership of property because it is vacant, abandoned, and essentially no one has exercised control over it sufficiently to maintain it in a condition that is compliant with code. So in order to facilitate that occurring, the court can, well, the local government, meaning town, village, city, etc., can bring an action under the state statute that gives them the right to seek stripping away title from whoever the owners of record are, and deeding that property to someone else in order to bring it back into compliance with code and make it a productive part of the community. It's not a common remedy, but it is available. I know that I have issued maybe a half a dozen forfeiture judgments in my experience. And normally it comes with a consent decree, meaning that whoever is going to be ultimately deeded the property, they will agree by this consent decree. First of all, they appear in the case, so they subject themselves to the court's jurisdiction, and they enter into a consent decree where they agree to bring the property back online, meaning cure all the building code violations within approximately a year. Now, the year is not necessarily a hard date, but it's a target date, such that if meaningful and significant work has taken place, if you need more time than that 12 months in the consent decree, typically it will be allowed. But the goal is to bring the property back online and put it in the hands of someone uh, who has the means and ability to, uh, to cure the defects that exist, the code violations and such, and make it productive again.
All
So,
right. All right. We are certainly running out of time. And I think we should certainly continue this um, next week because a lot of people fall into this. Just in comment, what is most common that you see when it comes to people in that works against them? You know, that works against the average ordinary person who doesn't have the wherewithal to afford an attorney, and they have to uh, defend themselves on their own because they just don't have the resources to do it. But what's the common problem that you see with most people who having to represent themselves?
is this litigation in general or housing court in
Just in
particular?
general, yeah,
I think
yeah.
maybe operating under the belief that I'm not going to be listened to and given an opportunity to give my side of the story.
Hmm.
Um, so I think that's a false notion that folks should not labor under. Um, I believe, I know I listen to pro se litigants all the time. Give them a chance to give me their side of the story to be heard. And
I think um, we lost Judge Murray there. For some reason, he'll come back. But yeah, I think when we're talking about showing up to court, there's some very key, important elements, even if you're just representing yourself. Now, the court, I know, can be very intimidating just thinking about having to go there. But, at some point in time, you're going to end up before a court. And there are some very basic things that you should know going into court. One, they're not monsters. Judges are not monsters. They're going to equally hear you, even though you don't have an attorney. That is not a court is not looking at you in a negative way because you don't have an attorney. In fact, they're more sensitive towards you because you don't have an attorney, because in most respects that people go to court without an attorney is because they simply can't afford it. And so the court will do all it can to make sure that the process is fair and appropriate for your particular situation. So the courts are not out to rule against you. Excuse me. To rule against you because you don't have an attorney. Just like the false nomer of the banks interested, they want your property, and so they're hoping that you default and when you go into foreclosure, but they want your property. That's really not what the court is interested in. They're just the court is not. First of all, the court is not enforcing that sort of thing. In the bank, really, they are not interested in that. That's not what their motive is, or their motive is that they want to provide a loan, and providing a loan that you would pay according to the terms and conditions of that loan to be a long-term successful asset for them, as well as it becoming a successful asset for you. So the court and the banks, they're not interested in taking your property. As a matter of fact, just to the very opposite, that the banks are not interested in taking your property because, number one, they have to insure it, and two, they have to um, make sure that the property is going to be um, okay. So, but they're not interested in taking your property. It just brings on more work, more liability for the institution. It's an asset as long as it is a loan that is um, performing. When it is not performing, it is becoming a liability to that entity. So, and even if they have to take it back, it is not a benefit to them. It is just that is the last remedy that they have available to them by a court to eliminate the the debt that has been expended. So, and in most cases, they don't get it all back. It becomes a loss, a net loss for the institutions. All right, so we're going to talk. We're going to continue this conversation next week, uh, talking about forfeitures and all of your legal concerns. I know that we got started just a few minutes delayed today, and maybe some of you don't think, but you can always go back and you can get the program. Go to my YouTube page at Mark Wallace, The People's Show, and you'll be able to see. You can look at all of the various podcasts that we have recorded, and you can view them again. So please like and share the information when you see it, as we certainly want to get more people involved and participating. And again, if you have questions for Judge Murray, you'll be able to write them in the comment section, and then he can respond to your questions. All right, that's going to do it for us for this week, this Saturday edition of the Legal Hour with Judge Leonard Murray. I'm Mark Wallace, your host and facilitator, here with you every Saturday from 1 o'clock until 2 p.m. Coming up on Monday night, the Monday night edition of The People Show on intellectualradio.com, Instagram, YouTube, Facebook, and X, formerly known as Twitter. We are going to talk about education, meaning the Board of Education and the elections that they are running, as well as those seats that are going to be appointed by the mayor. It's so vitally important that we put ourselves in a position of strength, which means that we have to be connected, we have to be collective, and we have to collaborate in order to put ourselves in a position of strength to make sure that people who are in public office respect our communities and don't overlook our communities. As long as we are fractionized, as long as we are not organized, and as long as we are not connected, and we are running in these individual silos, individualism and individualistic silos, will continue to struggle to make significant progress. We have to build our independent voice of thousands of people connected that we can discuss, deliberate, and determine people in these various offices across the board. When we demonstrate that we have that kind of organized strength, our communities will have a difference in its appearance and its function almost overnight. So like I said earlier, when we just started, I came from a meeting today and listening to everybody, those people who want to run for who want to run for the Board of Education, and all of that sort of thing. We have the one problem that we have is that we have everybody running in all these individual spaces, right? All these individual spaces. But when it really comes down to it, in a lot of respects, we are not going to be the people who are going to make these determinations because collectively we are not organized. That's a really big problem. All right, I think Judge Murray is back with us, and so we're just going to wrap it up and bring Judge Murray back into the studio as he had probably some technical issues. All right, Judge Murray, welcome back.
Thank you.
So,
Yeah, sorry about that.
Yeah. Okay. All right. So yeah, we're just gonna wrap it up. Oh, I think there we go. We are going to wrap it up. You were making a comment. We were talking about were we on forfeitures or we on? I think we were on forfeitures, right? Judge Murray, can you hear me? Can you hear me? Judge Murray, can you hear me? Are you able to hear me? I can't hear you. I'm not able to hear you. I heard you when you initially came back. I'm not able to hear you. I don't think it's on anything on our side. Nope. Okay. Can you hear me now? I can't hear you. I can't hear you. We're having Judge Murray, can you hear me? No. I'm not able to hear Judge Murray. I'm going to bring him off and then we're going to bring him back and see if we can work out these technical issues. Okay, Judge Murray, can you hear me? I can't hear you. I'm not able to hear you. Okay, let's see. All right. I can't hear. I cannot hear you. All right. All right, folks. For some reason, I'm not able to hear Judge Murray. Something's wrong with our audio at the moment. Not sure what it is that we can't hear him. Okay. All right. Well, listen. I want us to. Well, I'm going to continue until we can try to see if we can't get his volume or certainly his audio back. But my mission is our mission. We started 10 by 10 to win back in 2017, and the objective is to build an independent voting bloc, meaning to build the strength, really to build the strength, to unionize us in a way that we are going to strengthen ourselves to make sure we can make our own decisions on who it is that's going to represent us. Our representation should not be in the hands of any politician. There should not be a single politician, not the Democratic Party or the Republican Party. They should not be determining who it is that we can vote for or telling us who it is that we can vote for. Now, I am in no way speaking against the Democratic Party. I'm a registered Democrat. But what I'm saying is that voters, we should be the ultimate decider on one, who the candidate is, and two, who becomes elected. It should not be the party putting up a slate of candidates telling us these are the people who you have to elect, or these are the people who are going to be elected. These are the people who they want, not who we want. That we have to, that has to change. All right, Judge Murray, we're going to try to see if we can get you back. Are you
Okay.
back?
Yeah, I
There we
didn't have any audio when
Okay.
I joined you a few moments ago.
All right. Okay. All right. So we were, where were we? I sort of lost a place I was carrying on talking about.
I think we were
Organized.
talking about that even pro se litigants should not be fearful of coming to court.
Yeah.
And that it's important that you show up because you should be given a chance to explain yourself, to give your side of the story. But if you're not present, then of course your side of the story is not going to be told. So that it's vital that you show up and shouldn't be fearful about that. You know, these courthouses, these courtrooms, and all the staffing and so forth is paid for by taxpayers. You know, by all of us. So you're entitled to enjoy uh, the fruits of the tax dollars that you contribute towards running these places. And you know, don't forget that you know you pay the salaries of judges, the clerks, the sheriffs, uh, the interpreters, you name it. It's all public dollars. So you should enjoy the benefit of what you contribute towards supporting what it takes to run these facilities. You know, both state and federal.
Right. Right. Yeah. I know that some people, excuse me, some people are intimidated by the idea that, let's say a person who was in foreclosure who says the bank, they just want to take my property. They want to take my property, which is so far from reality, far from the truth. The bank really wants you to be able to pay your note, because as long as it is a loan in good standing, it's an asset for the bank. When it becomes a loan that is in default, it becomes a liability for the bank, and they're not interested in you defaulting so that they can take your property. It just doesn't work that way. Nor is the court interested in taking anybody's property. Now, you may have some people who are out there that may be functioning adversely to that, but the court overall, their objective is really to protect the public, right? Protect the public under the Constitution, for which we all have to abide. Judge Murray, I think your audio is out. Your audio is out again. Your audio is out. All right. Well, listen, we're having some technical glitches here at the end, and we're right here towards the end. This is what happens when you do live, but that sort of thing happens. But we're gonna call it here. We'll be back next week with another edition of the Legal Hour with Judge Linda Murray, and hopefully we'll have all of these technical glitches taken care of, and then we'll bring you back. All right, I'm going to try to bring him back one more time. We're going to close it out.
Yeah,
All
I'm
right, Judge.
sorry. Just
Okay.
some reason someone called me, so I'm not sure if that's. I didn't take the call, but it interrupted the audio.
The audio. Okay. All right. All right. So we can wrap it up here, but I just wanted to get your take on that. So I was just basically telling people that courts are not interested in taking your property. The banks are not interested in taking your property. They want for you to be able to perform according to the contract. But if you don't, their only remedy is to go to court.
Correct. Yeah, they can't come out like the example that you gave of apparently property manager being sent out by the lender to take over a location without authority. So their authority can only come from a court order, and they had no such court order. And normally, during the height of COVID, I'll say, there was a program put in place because so many people were economically devastated by losing jobs, the work hours shortened, any number of things that limited their economic vitality. That the lenders were overwhelmed with the number of defaults that they had, and there's no way that they could have taken all those properties back. So there was a plan put in place to try to mediate the situation through the courts to see if folks could work out a basis to reinstate their mortgages, or even in some instances rewrite the mortgage, so as to allow families to continue to live where they were. I wasn't directly involved in that, but what I'm told is that it was helpful to many people, and the lenders contributed to the success of it as well, because there's no way they could take back all the properties that were underwater and in default during the COVID era.
All right. That's going to do it for us this week. Judge Murray, thank you so much. We'll work through these technical glitches on next week. We will bring you another edition of the Legal Hour with Judge Leonard Murray on next Saturday with some new topics, and make sure that whatever questions that you have, think about them throughout the week, write them down, and then you can send them in through the comments, and we will read them off. And then Judge Murray will weigh in and respond to all of your legal questions. I want to thank you all for joining us. Thank you so much, Judge Murray. We appreciate it.
Yeah, thank you, Mark. I enjoy it.
Okay. All right. Talk to you soon. All right, folks, that's going to wrap it up for this week. And so don't forget Monday night, going to have a great program. I'm going to be talking with Kim Delaney at the DuSable Museum. And we're going to try to put together a program for Monday night's edition of the People Show. So I'll be talking to her right after this. All right. Thank you all so much for tuning in to the Saturday edition of the Legal Hour. Go out and have a great weekend. Be safe. And until we talk to you the next time,